In his heads of arguments filed in the SCA, Zuma says the attempts to get him back in prison are doomed to fail due to the misinterpretation of the law. Zuma says the Correctional Services Act empowered the National Commissioner to act decisively and to protect the rights of an inmate to adequate medical treatment.
It would appear that if one looks at the previous judgment, there was also consideration of the application of Section 79. And my view is that Section 79 seemed to be to deal only with medical parole. But this one grants, the Section 75(7) grants the National Commissioner powers to make such a determination. So in as far as that is argued in court, there are prospects of success in my view.
The Helen Suzman Foundation, the DA and AfriForum contend that Zuma did not meet the prescribed criteria to be released on medical parole. They argue that Fraser was duty-bound to uphold the recommendation of the Medical Parole Advisory Board not to release Zuma. They further submitted that the Correctional Services Act did not grant an overriding power to avoid the criteria prescribed for medical parole.
Applicant for consideration of medical parole must be terminally ill or physically incapacitated. Now, this is one aspect of the requirements which the respondents in this matter, in this appeal, seek to argue that it has not been fully satisfied. In actual fact, they base their arguments on the decision by the Medical Parole Advisory Board.
In its judgment in December, the High Court ordered that Zuma be returned to custody and serve the remainder of his sentence. It declared that the time Zuma spent out of jail on medical parole should not be counted towards his 15 months sentence. Zuma and the Department of Correctional Services will have to convince the SCA that the High Court erred in its judgment. Makhala Masiteng, SABC News, Bloemfontein.